everybody. What is the one thing you cannot say as an attorney in a civil jury trial? So if you're doing a case of personal injury, whether it's a car crash, truck accident, slip and fall, ceiling collapse, any kind of personal injury, and you're the attorney for the plaintiff, what is the one thing, the one word you cannot say in court? And the answer is insurance. You can't talk about insurance. And the reason is because it could be so prejudicial that the jury can then conclude, which, they can kind of conclude that anyway if they, just pragmatically and being intelligent jurors who live in our community, they could probably conclude that anyway. But the idea behind the rule is that if they think that there is insurance, then they may not be fair because, everyone knows insurance has a lot of money. And so you can't mention insurance. Now, the only time you can bring up insurance is in jury selection, where you could ask the prospective panel of jurors if they or a loved one or anyone close to them is either employed by an insurance company or has a financial interest, such as holds stock in an insurance company. Because if they are employed by an insurance company, you can then get them off, especially a liability insurance company like State Farm, Progressive, Allstate. If they work for one of those companies, or if one of their family members works for one of those companies, then that could be a reason to get them off for cause. And that's actually in the New York jury rules. So then that's one of the questions that you can ask in jury selection, but then you cannot bring up insurance again throughout the trial. So what do you think about this rule? Do you agree with it? Do you think it makes sense, or is it a little bit antiquated? Because it's kind of like the elephant in the room, right? And then it also allows the defendants to then paint a false picture, right? Because you as the plaintiff's attorney can't bring up insurance. So then what do the defendants do? Well, they can, say, look, they're suing this poor little old lady. And if, what are we going to do if you allow for like $1 million? If you award that greedy plaintiff $1 million, how is this poor little old lady going to pay? She's going to lose her house. She's going to be devastated. So they could paint this false picture, whereas in reality, you're not suing the little old lady. The little old lady is just the policyholder. You're suing the insurance company, and the insurance company has like $1 million policy that they can pay, that they're choosing not to pay, that they're, deliberately choosing to save their money because they think they can get away with it. So let me know what you think about this, but I think it's an interesting issue, and it's definitely one of the rules that people don't always know about. So it's interesting to educate people and to explain that is the rule in most courts throughout the United States. Okay, everyone, thank you so much. Talk to you soon. Bye-bye.